All rise. You all welcome to be seated. The next case of oral argument is Green Gables Apartments versus AHG Tax Credit Fund et al. Council, good morning to each and all of you. To appellate's counsel, how much time for rebuttal would you like?
5 minutes, sir.
5 minutes. You're welcome to proceed when you're ready.
Thank you, Mayor Free's Court. Presiding over Sal, Lane, Shea, Marshall, City Council. My name is John Hayes. I'll be representing the appellant in this case, Green Gables Apartments 2 Limited. I'll refer to them as Green Gables or the appellant. I'll refer to the appellee as appellee or as AHG. The sole basis for the summary judgment below this matter was that Green Gables presented the wrong certificate form in among a very long list of documents to request a $1.2 million capital contribution from AHG. There are broadly speaking 4 separate bases on which reversal is required in this case. And each one independently would be a basis for reversal. The first is that the facts of summary judgment show at least substantial questions related to whether Green Gables substantially complied with the funding requirements of the matter. 2, the requirement for the relevant certificate was either waived, the requirement was modified, or AHG should be stopped from asserting the differences in form as a defense. 3, AHG failed to make a critical component of its case. That is, failed to show it was entitled to judgment by failing to show any prejudice as a result of the differences in form. And 4, finally, summary judgment was premature as substantial and important discovery was outstanding at the time of summary judgment.
Mr. Perry, let me ask you, I'm looking at the order granting the partial summary judgment, and number 8 says Green Gables failed to send a partnership/general partner certification to AHG in support of their request for the installments, and has today never sent a partnership general partner certification.
Yes.
Is that true?
It is.
Why not?
It is.
Why do we come with that?
So we requested, AHG requested that we not use the partnership general partner certification form that we use to borrow an general partner certificate. Now, one of these is required by the language of the contract, and one of them is not.
And counsel, when you say that it was requested that you use that other form, are you referring to Mr. Murray's email?
Yes, sir.
The April 11, 2006 email?
Yes, sir. And that is the email that confirms the understanding in and among the agent of AHG and Green Gables. In fact, 7 times the same form was submitted to AHG. A total of 19 times this form was submitted before and after that email.
But counsel, that email is referring to a specific disbursement, correct? That it's number 11. There is no indication that here's your form, you should just use this other form and you'll be paid. There's specific, and even I believe an attachment to that email delineated the different types, there's 4 different types of payments. So, how do you respond to that with respect to Judge Shea's question?
Well, Your Honor, first and foremost, I would direct the court to page 13, 343 of the letter. That is the component of the partnership agreement issue. And that is the general conditions for all installments. The borrower certificate is not necessary. The partnership general partner certification is necessary. For simplicity, I refer to it as the partnership certificate, which is how we actually refer to it in brief. We would also often refer to it as the GP, general partner certificate. The GP certificate was a requirement for each and every case, but it said, based on the understanding between Green Gables, also based on the written request from AHG, the borrower certificate was included each time. Now, what I believe is argued is that, well, the borrower certificate was for those earlier things, despite the language. contract requiring the GD certificate in every single case. But the borrower certificate was appropriate because it was a loan agreement. And the loan agreement is what governs further agreements, not the partnership. Now, they have not quoted any loan agreement between Green Gables and NHG. What they pointed to is the joint funding agreement between Compass Bank and Green Gables, where AHG was a signatory as the investor in the partner. There are funds exchanging between AHG and Green Gables under that document. There is also expressly not a single mention of the borrower certificate in that agreement. On page
Mr. Hayes, back to the order granting the motion for partial summary judgment. 17 says Green Gables used the same borrower forms to make the request after AHG became a limited partner. AHG accepted the forms and paid the requested contributions for 7 of the requests until they rejected the 19th request. I assume you don't have any problem with that. That's all factual, correct?
that is understood.
And then the order says the 19th request is a different type of request than the first 18. Is that true?
That is not true.
Why?
It is different only in the sense that this is the primary and sole economic benefit to Green Gables. This payment is as the benefit of the bargain for Green Gables. It is not different in any material respect. In that we've had a schedule for each type of payment that we required previously. We've had different milestones that have to be met for each type of payment. Each step along the way there are different requirements. There's nothing categorically different about the signing other than the fact that
And background, I don't know if you have the order granting motion for partial summary judgment in front of you, which is sort of the basis of why we're here today. But then the court says the first 18 requests were draws for the joint funding agreement. And then it says the 19th request was made on February 4, 2010 and was for performance in 8609 installments per the agreement of limited partnership. Is that true?
No, Your Honor. And this is a critical component of why Green Gables failed to demonstrate why they were entitled to judgment at this stage. Separate from some of the other elements to talk about in a moment, critically, there was a meaningful difference between this final installment and joint funding installment. There was never been demonstration or evidence that there was a difference between these. In fact, if you look at the draws that we submitted evidence, I believe it was number 11, was the first draw that did not include any limited funds. That is, at some point we got the limited funds to zero. So this
Where did this come from, Mr. Hayes? Did the court just make this up?
Your Honor, I was part of the proceedings, so based on later proceedings from the same judge, my anticipation is that it would be from a proposal.
The proposed order from the defense.
Yes, sir.
Was there an objection to that? An objection to the proposed order as being factually inaccurate?
My guess was that there was a motion for hearing, there was a motion for reconsideration. Both following the time of motion for hearing and motion for reconsideration after substantial discovery was actually applied.
And the motion for hearing and reconsideration, did it go through and say the court was factually wrong about these items I've just recited?
Your Honor, we made also arguments related to actual inaccuracies of that and also others not prepared to represent that. But I'd be happy to read that for Your Honor, related to specifically whether or not that was objected to. I do not believe that I believe in this argument or not, that we failed to observe any arguments related to factual inaccuracies in the summary judgment order. It's been our position from the outset. There was not a distinction that, in fact, we were required to provide borrower form in a case like it was assigned, that instead of performing or even notifying Green Gables, that there was some issue now with the form.
That thing on, again, the order granting the motion for partial summary judgment. Item 24 says, in her letter, Ms. Calise, I think that's Neil Police informed Curtis that he had not provided the partnership general partner certification as required by the agreement of limited partnership. Did that happen?
It did not.
Did not happen.
There was a letter. The letter mentioned certification. The letter lumps together Wichita Station, which is a co-plaintiff below, and Green Gables. The letter does not say the wrong form was submitted. The letter says, this is required, partnership and partner certification. Their representation throughout and until summary judgment was that plaintiffs failed to provide any certification. That is, they didn't give the partner certification, they didn't give borrower certification, they didn't give any certification. It was literally an actual advice at summary judgment desire that they believed that Green Gables had provided certification, but that it was the wrong one.
So, just so we're clear, as a panel, you're saying this never happened. This police never informed Mr. Curtis that he had not provided the partnership general partner certification.
Your Honor, I think that is absolutely inappropriate interpretation of facts at the summary judgment stage. The court is free to read page 8640 of the record and page 641. That's what the letter is. If anyone else would interpret this letter to be saying we sent the wrong form, borrower certification form was sent, and instead we need the general partner certification, I don't see it. The judge see it, and frankly, don't understand what really happened. There is no reference in there to the wrong form. There is no reference in the affirmative defense to the wrong form. There we also have this grouping where all the plaintiffs, all the defendants are grouped together. There's no distinction between who did what. What are they supposed to do? And regard that simply insufficient as a pleading matter to put us on notice.
Well, counsel, since you brought up pleading matters, you mentioned waiver on the stop.
Yes.
Where were those pled below? Were they ever pled as avoidances in this case?
You're already on those avoidances. However, the vote was the Affirmative Defense Act. It's very complicated to be an avoidance. We don't have the affirmative defense pleaded first. We could have pleaded an avoidance to say the affirmative defense is avoided because they didn't plead with specificity to provide us any.
They didn't amend their affirmative defense and specifically indicate that the form was not received, that you sent in the wrong form, the borrower certificate as opposed to the partnership certificate?
No, those
Did you indicate that in your initial brief, that you would have pled this, but you didn't know?
I did not plead that we would have pleaded a general law.
You didn't mention it at all in the
That's
initial brief, correct? You just acted as though it had been asserted below. Did it not, correct?
It did not.
Waiver or estoppel?
That's right.
Okay, and as a review court, why should we look at that now?
Well, Your Honor, I think it would be what's good for the goose and sensitive for the gander. If they're able to receive summary judgment on an affirmative defense that wasn't pleaded, we should be allowed to at least argue that an avoidance of that affirmative defense should not stand as a basis for summary judgment.
But counsel, you didn't make that argument on appeal. You didn't make the argument that that's why you didn't plead it. You just indicated that now you would like us to reverse on those grounds. So, please, if you could just clarify that for the panel.
And Your Honor, I hardly agree there was no reply filed, so there was no avoidance as to these. And the fact that they did not plead, I do believe was raised below, although not raised in the initial brief. And respectfully, the arguments have never been the same from the plaintiff's perspective.
So you say it was raised below, was it objected to below?
Was our argument below?
Correct. You said it was raised below, not raised in your initial brief, but when it was raised below, was it objected to?
I think I'm right.
You're not telling us it was tried, that issue was tried by consent below.
There was a problem. So that you're holding us on a summary judgment based solely on.
And that's the current part. I use that as a the term hard. I fully appreciate it. You're not saying that was advanced, and with the acceptance of the other side, that was something you were allowed to argue. Hold on.
I can't see this manifest in the direction of being able to raise or agree with the raise, in particular on the motion for consideration, if they're, on that motion for consideration. And if the court finds that in fact those are unreserved and one basis to reverse, that I would direct the court instead to both the substantial compliance centers and the overwhelming failure of prejudice in this center by the complaint, or excuse me, by the appellate. The whole case here boils down to the fact that what appellate says they wanted is a certification that all of the representations and warranties in the agreement and all the project documents are true. That's what they say they want. That's the DEP certificate. What they got instead is a document that says all representations and warranties contained in the loan agreement and the loan documents are true.
And counsel, just as I see our time is dwindling here, I want to just focus on one other issue that you mentioned, that summary judgment was premature.
Yes.
So this is a lengthy record, almost 16,000 pages, and I took a great deal of time because that is concerning. Some of our precedent is broad when it comes to that, especially under the old summary judgment standard as we are here. But it's concerning to me. So the summary judgment occurred in what, August of 2019, I believe. Then the order came out in October, I believe, of 2019. So, or December, it was October and December, I'm sorry, of 2019. So then there's this motion for rehearing, and then an amended motion for rehearing. And in that amended motion, now you say there's this newly discovered evidence. There's 15,000 pages. We're still reviewing it. And then there's an order that's, reserving jurisdiction for the trial court to rule on a motion to compel. Well, I was confused because when I read the transcript for the summary judgment hearing, there was nothing alerting the trial judge that there was this motion to compel and we shouldn't go forward here today. In fact, it was minimized to the trial court, and there was an indication about something not being signed, but it was almost done. And then I went back, and I was confused about that. And when I reviewed the record, best I could tell, there was no motion to compel filed when the amended rehearing was filed. It wasn't filed until 2 months later. The documents that were attached, again, best I could tell, because there's nothing indicating in the briefs that these documents I assume were produced by Wells Fargo based on the dates numbers. But it appeared as though those documents were not, they may have been newly discovered by counsel, but they were not newly produced. So how is it premature? There was nothing indicating, just because there was outstanding discovery, if you sat on those rights, how does that make discovery, or summary judgment in this case, premature?
Thank you. There's two key components. I just said that in my overall. There's two key components. One is was there a motion to compel? I'm saying no, it was not, because in the reading motion to compel, there was already a notice of going to the briefs, and it was agreeing with counsel at the time of summary judgment that we were being considered records. The level of fundamental nature of this, of the discovery issue that was outstanding, was what did we send to AHG, and what did AHG receive, and who controls AHG, who is entitled to find AHG. Both of those issues at the summary judgment level, both of those critical questions, and that was the level of sort of basic level of discovery that is so outstanding.
But counsel, isn't that incumbent on trial counsel to say, hey, this is still outstanding, it could be really important, we can't go forward here today. But that's not what happened here. There was nothing. There was nothing until there was an adverse summary judgment entered, and then it was, oh wait, these documents are out there, and there could be more. So why should this court look at that now?
And you're right, I don't believe that opposing counsel has made that argument. I don't believe AHG has made the argument that this is failed to preserve. However, it is important as to quality review and the civil review of this case. Importantly, we have no review for the order of the judge review. with that, I was there.
Thank you.
Council, thank you.
Thank you, Your Honors. May it please the court, Jason Maroon for the appellate. I'd like to go through and actually address in further detail some of the questions that the panel has raised. They are very specific and they're spot on in the appellant's view. Let me get one thing out. That summary judgment order that Your Honors was reciting, that was crafted by the trial judge from scratch. It was not a proposed order from counsel. That was a very careful order, as Judge Jay went through, and took the Marion County judge a good amount of time. That was all his own work. It was not a proposed order. I wanted to correct that. Mr. Hayes was not a part of the proceeding at that time, so obviously we understand the misunderstanding, but it was the judge's own work. Perhaps the most curious argument in our view is that the plaintiff was not put on notice of this issue. It is actually quite the opposite. Over and over, to Judge Colmay's point, in the response to pleadings, we alerted meetings, you have not submitted the proper certification under Section 3.3A of the partnership agreement. It comes up over and over and over. In fact, early in the case, in 2016, AG defeated Green Gables' motion for summary judgment, their own motion for summary judgment, on the basis that the certification was not provided. This is 3 years before the summary judgment proceeding that issue here. Forgive the tedium, but I would like to go over specifically what I'm referring to. And I think we have to start here because logically, if the issue is not preserved in the pleadings down below, we have to stop there under the rules. So let's go back and I'll give Your Honor the record site. So I'm looking at the initial answer to Green Gables' complaint. So this is going back in time all the way to 2015. And this response to the pleading is record page 839. And this is just the beginning, as you'll see, it gets more and more specific as the years go on. And this is not a kitchen sink defense. There are 3 targeted defenses that AHG put forth. The third one, in very simple terms, I'll just read it. Quote, for its third defense, defendants state that plaintiffs have not complied with the preconditions necessary for payment of the disputed capital contributions, including the preconditions appearing in Section 3.3A and Exhibits A through D. Exhibit D is the partnership general partner certification. It goes on in the following sentence, quote, plaintiffs did not satisfy these requirements on various levels, including their failure to sufficiently provide the necessary certifications. So we're going back
To help us understand, counsel, what you're saying is it was pleaded in 2015, pleaded with specificity that this precondition to payment was not met, and if they thought it was waived somehow, or that your client could have stopped from asserting it, their reply should have happened right in real time. Correct? Is that what I hear you saying? And by virtue of that not happening, you're saying that was waived by them, their avoidance not being advanced at that time in 2015.
That's precisely correct. And in fact, it's actually respectfully, even factually worse for the appellant. They plead the opposite in their reply. And just for the record, I was reading record page 857 just now. Let's fast forward in the record to the plaintiff's reply. And, Your Honor, this starts on record page 2508, and I'm going to specifically 2510. The response to the affirmative defense we call conditions preceding. They not only did they not say, well, even if that's true, that the certification was not presented, we seek to avoid it by way of a stop waiver. They say the opposite, and I'll read it. Quote, in reply to defendant's second affirmative defense, plaintiffs state that all conditions preceding have been met for payment of the disputed capital contributions that defendants failed to pay. Plaintiffs deny the allegations in the second affirmative defense. So, again, it is the opposite of what they're looking to do to preserve. We have the right, as the appellee, as a defendant below, going into summary judgment hearing, to know what their position was. We rely on these pleadings as we're allowed to do under Rule 1.100A. We have a right to know if they have a basis to avoid our defense that they didn't follow the contract, then we will need that avoidance. We didn't have that opportunity. And I hate to keep piling on, but it actually gets worse than that.
Well, let me follow up, and from a pleading standpoint, it sounds like you're spot on, counsel. But Mr. Hayes intimated, I thought I heard him say it, that waiver of estoppel was argued below. One, was it? Two, did your client allow that to go forward without advancing this argument or not?
Understood. Waiver was not argued below, as we saw, not preserved in the pleadings. Now let's go to the litany of summary judgment filings. I can say this categorically. In the opposition to our motion for summary judgment, waiver was not argued, 100%. Now, they argue course of dealing, which is a separate concept under Florida law. Now, after they lost the summary judgment, this keeps going on. The plaintiff files a motion for rehearing. No mention of waiver, the word is not there once. They then amend, without leave of court, their motion for rehearing, argue additional points, piling on discovery, as Judge Chilton noted. No, not a single reference to waiver. This goes on. 4 days before the trial, with the other plaintiffs below, they move for reconsideration, asking if the court would hear the Green Gables case at the trial and essentially vacate the summary judgment. They argue at length again, not one single reference to waiver. The first reference after the summary judgment proceedings regarding waiver is in this case. And
so, I mean, not to play with words, waiver with waiver, many times.
That's correct. Just going back to the beginning, 1.100 says if you seek to avoid a defense, including the waiver, you have to plead affirmatively as an avoidance for your waiver. That's exactly
what about estoppel? And estoppel may be different. Was estoppel raised below?
It was a very, so in opposition to summary judgment, it was not. It does not appear once in the briefing. In the motion for rehearing, no estoppel reference again. In the amended motion for rehearing, once again, no reference to estoppel. In that last filing I mentioned, in the motion for reconsideration, it was July 15th, 2021, in a trial that started 4 days later. They first mentioned estoppel before the trial started. At that point, years after the summary judgment hearing. And at that point, we objected on the basis that that's a required avoidance. It was not completed, and nonetheless, we were able to provide that for the appellate.
I asked Mr. Hayes a question about number 19. The court's order granting the motion for partial summary judgment. 19 reads, the 19th request is a different type of request than the first 18. Mr. Hayes says it was not. Is that 19th request different than the other 18?
It absolutely is different. It is categorically different. The reason is, and we briefed this, all of the installments up to the two that are disputed here, the performance and the 8609 installment, all of the previous installments, and the big ones installments are funny names, the 50% construction completion installments, those were construction costs. The big distinction is those funds were loan funds and equity funds. And in order, this is from the summary record transcript, just to show that there was dispute over this. Record page 8625. This is Green Gables Council at the summary judgment hearing at issue here. And it's very clear. Page 55, line 20, Mr. White said, quote, there's construction going on, and the bulk of that is loan money. So it kind of makes sense why I would say borrower certification or advance requests. Close quote. So what is being confirmed there is that all of the money up to the performance installment includes loan funds, and therefore the borrower certification would have an application. When you get to the performance installment, there is no loan funds whatsoever. So the judge was 100% right. That was a different installment particularly with reference to a dispute where there's a certification regarding contribution funds versus loan funds. And if you want the absolute technical answer to this, and I apologize for you having to read it. It is a bit of a dense provision, but it is exceedingly clear. This is in the record at page 7808, and this is the joint funding agreement that council earlier referenced, and the concept actually is not complicated. When you have these big deals, and you have what is in essence a bridge loan to help the developer get to the end of the project to help ends meet while the limited partner is providing funds, the funds are mixed together. So the developer grabs some loan funds when they need it, and they also take a combination of equity funds. So where that actually appears, and it's unmistakable, it is at page 7808 in the record. It is section 3A of the joint funding agreement, and it breaks it down into how this money is paid. And I won't give you the mouthful, I'll just paraphrase, but what it says is, it refers to, quote, then with proceeds of the term loan in an amount sufficient to complete 50% of the construction. And that's what I was referring to. The construction draws were for that 50% completion phase. But then the next part is the most important. Then when it talks about the performance installment, it doesn't say that's drawn from the term loan. It says that it's paid by the investor limited partner. So that relevant portion is, again, on 7808, quote, investor limited partner, not the lender, the investor limited partner will disperse to partnership the performance installment in the aggregate amount up to $1.132 million for the payment of developer fees in the same amount, and then it references the 8609 installment for the same. It's a very clear structure. The joint funding agreement says, up to the performance installment, we're going to mix the funds, here's how it's going to be paid. When we get to the performance installment, then that's the investor limited partner money, that's not loan money. So, when the plaintiff in the able to try to earn the course of dealing down, well, this why it didn't work. As Judge Hodges presented in his careful order, he said, look, for those earlier installments, there were borrowed funds. So the fact that Green Gables submitted a borrower certification had an application. Now, for the performance of the 8609 installment, where this would be a 100% mismatch, this is just not the correct certification. And one narrative that appears throughout the appellant's brief is that this is just a form.
Another question.
Yeah.
I heard you say earlier in your argument that Ms. Calise did inform Mr. Kurtz that they had not provided the partnership general partner certification. And I know that's the position below, that's obviously what the court found. If in fact that happened, and it appears it did, why was it not rectified? Why was it not corrected? Why did they not provide the form?
That's a good question. We don't know what's in the mind of the principals of Green Gables. Our belief is they were not able to certify those matters in that partnership general partner certification. If you look at Ms. Calise's letter, I'm looking at it, February 4th, 2011, the first page and a half is actually very dense in terms of the analysis and metrics that this investor had to perform in order to fulfill its duty. And the calculations are actually quite complex, and it's what Judge Hodges dealt with at the trial down below. But what Ms. Calise concludes is that, look, we've run the numbers, you cannot certify that you have earned the performance installment because you haven't met these fairly complicated metrics involving debt service coverage ratios and other contractually designed formula to show that this apartment complex really is done, you have earned the money, and the certification is appropriate. So, and what's strange about this appeal is that there was a summary judgment years before. The case goes on with 3 other plaintiffs, gets tried, and we have the summary judgment record citing 10,000 of pages because it's an entire trial record. But if for anyone who wishes to delve through that, you will see a lot of the evidence where this certification was just a threshold requirement, and a very important one to trigger payment. But on top of that, it was the investors and the sponsors' obligation to make sure the certifications were correct. So to answer your question, our best assessment is that Green Gables was not able to accurately certify, and they were resistant. And this brings up another point that was argued extensively before Judge Hodges, and that is, even if you were to take the borrower certification, it wasn't even signed. If you look at Ms. Hale's affidavit at paragraph 23, she lays out the narrative and attaches what was submitted, and that attachment as an exhibit is an unsigned borrower's. So this is in the record at page 7823, and paragraph 23, Ms. Hale lays out what exactly was submitted, and then if you go to the exhibit C that's being referenced, it's an unsigned certification. So you'll see this theme in the summary judgment transcript before Judge Hodges. We're saying, I think rightly so, an unsigned certification is no certification at all. So it's the wrong certification to the wrong party that affirms the wrong content. And I can get into this if you want, but if you juxtapose the partnership general partner certification and the borrower certification, it is not substantially the same. In fact, every paragraph except for, I believe it's paragraph 11, is different. Entire paragraphs of the correct certification are omitted from the borrower certification. So even if you said, well, lender and investment partner are the same thing, even though they're not talking about loan, they're talking about partnership agreement, I won't go through this tedium with you, but if you put them side by side, they are very different documents. For example, the last part of the certification, for the proper partnership certification, there needs to be a warranty affirmance for the reps and warranties in the partnership agreement for sections 6.09 through 612. Omitted from the borrower certificate are two of those very material warranties, one of which actually is a detailed rep and warranty regarding the integrity of the construction of the apartment complex itself. So this is very material. This is the triggering document for payment. It's not just a form. It's not substantially the same. It is quite different. So going back to where I started there, we believe that Green Gables could not certify, and that's what Ms. Solis says to the panel's question regarding what exactly did you say about the partnership, general partner certification. So this is in the record at page 1712. She lays it out. Second paragraph, quote, in no event shall the investor limited partner be obligated to provide an installment prior to the receipt of the partnership or partner certification. She goes on to say on the same page, Exhibit D of the partnership agreement is the certification, which certifies that all representation and warranties contained in the partnership agreement, all the project documents, are true and correct. As we saw, the borrower certification omits two of the material warranties. And here is where I believe the dispute is. Here's what Ms. Solis actually says about whether this was submitted or not, or whether it could be. This is in the record at 1713, page 2 of Ms. Solis' letter. She concludes, after doing this very careful numerical analysis, quote, as such, you are unable to sign the partnership general partner certification because you cannot certify that all the representations and warranties contained in the partnership agreements and project documents are true and correct, and that no defaults exist, which are requirements for any equitable release. So Green Gables quibbles with this, and they say, well, you didn't say you submitted the wrong form. But what Ms. Solis says is perfectly consistent with what happened. She said you were unable to sign it. They did not sign it. Even the document they submitted, the entirely incorrect borrower certification, itself was unsigned. So there's nothing inconsistent in Ms. Solis' letter. The trial judge got it exactly right in reciting it, and it's right there on the record. record site 1713.
And counsel, I see you looking at the clock, given the extent of question Mr. Hayes faced during his argument on behalf of the appellant, I'm going to extend each side an additional 2 minutes.
Okay. Okay, so that, how much time does that give me?
2 minutes.
2 more, okay, very good. I wanted to address Judge Kilbane's discovery question. First of all, just starting from jump here, this case has been pending for 5 years by the time we move for summary judgment on a very rare issue. Section 3.03 requires submission of a certification. It's a document presumably they have been in possession of and submitted it. Most businesses would have kept a copy, sometimes don't. So they had 5 years of discovery to find out where the certification went. And we had alerted them in defenses and summary judgment oppositions that you don't even get to the analysis of whether you're certified correctly when you haven't submitted the certification. And it goes on and on for years. This part is where the panel mentioned the Wells Fargo base numbers. If you look at the transcripts of the
That's my
summary,
assumption, counsel. I could be incorrect on that.
what you were correct. If you look at the summary judgment transcripts at 8625, counsel for Green Gables explained it to Judge Hobbs, and he says, look, and I'm paraphrasing, it's been 5 years, but there's been common discovery between the Alachua County case and this case. And so that was an explanation for why this took so long. Now that is a key admission here. By the way, there is no presentation by the appellant that these were lady produced documents. Where is the actual evidence of that other than just someone saying it in a brief? Here's the actual evidence. We have that reference by Mr. White in the transcript. If you look at the discovery that is now being rolled up years later to try to reverse the summary judgment, look at the bottom. It says WF on nearly every page of this supposed new evidence.
And counsel, your time has expired if you conclude your argument.
Sure, I'll finish with the sentence. What that Wells Fargo base number means is that that had been produced, in fact, years before the summary judgment in the pre-existing case. Thank you.
Thank you very much. All right, Mr. Hayes.
Thank you, Your Honor. Yes. To briefly address one of the, I think, critical questions is why didn't we submit it? And the answer is, well, at trial, we did submit a signed form. It's not a murder, we did submit it at trial. That was postdated to this application. However, this is not the kind of thing where you just whip out a signature and say, hey, as of today, this is the case. Each one of these requests for opinion includes hundreds of pages, often not hours.
You say it was submitted at trial, I mean, the shit that say it.
It's
game over by that time.
I agree. However, this is not the case where they simply would have accepted a later trial, a year later. And recall, the only thing we said did not occur for a full year after. This is a very simple case of harm. AHG got the benefit of its market. It got a request. It had problems with the request. But the time for performance was in 10 days. It didn't say we got to go forward within 10 days. It didn't say we were going to deny it within 10 days. The first thing that happened was a year later, we get a letter, and the court can make a letter on its own for what it says. But AHG got the benefit of its bargain. The bargain was not the form. The bargain was tax credits for them. The apartment complex was built. The tax credits are going to flow. We requested the money, essentially the only benefit of the bargain, for Green Gables, and we did deny it. AHG got it. We did. Their own witnesses testified later in trial. This represents a stunning windfall, unheard of in the industry. That was a testimony of Mike Lewis.
And counsel, let's assume, for the sake of argument, everything that you've said is accurate and true.
Sure.
What grounds would this court have to reverse? If you say that all of that is true, where is that in the record? Where is that in the
Yes, sir. The fact that there's many instances over and over again in the motion for hearing, motion for reconsideration below, and if you can't hearing, then motion for reconsideration below. Was that an issue at the motion for summary judgment?
Just sit down and motion that transfer.
No, so it was, now, clearly the position was, look, we tendered the documentation, here's the documents, they don't have any evidence on the side. It was called something different at the time, they used, close to the line. But there's a certain argument.
So council, and I think just one last question, I think that's the issue, right? Down below, the argument was always, we submitted the form, it's the same form, we complied, all conditions preceding have been met. Then on appeal, now we substantially complied, there's no prejudice. So again, where's the preservation? You say you raised it for the first time in rehearing, is that their argument?
I do, so, yes. Either reconsideration or hearing, get a little bit of this. And just to address one final issue, if I may, there was a statement that in this police case only the internal documentation that it received, and the under testimony trial demonstrated that this police, when she was evaluating this, she looked, hey, there's a tick box. Did she receive a GED certificate? Yes. The internal emails that we received demonstrated this had nothing to do with it. It had entirely to do with something else. And that certainly was a critical component of the argument. For those reasons, we request the approach.
Council, thank you very much.